Let's get on with the conversation out here. That's to do with Nasarawa impeachment plan. The probe panel set up to look into the allegation of misconduct and misappropriation leveled against the Nasarawa State Governor, Tanko Al-Makura, by the State House of Assembly has been dismissed by the panel that was put together by the Chief Justice of the state. Now, on Tuesday, sitting of the probe panel constituted by the state chief judge on the request of the 20 lawmakers out of the 24 of the PDP who were pushing the impeachment, the members of the panel set aside the allegation. So let's have this conversation now. And to talk about it with us is Hamza Mohammed, who's the Commissioner for Information in Nasarawa State. Good morning and welcome.
Good morning, Charles.
And then just on the other side, we have Wahab Shitu, who's a legal practitioner. Good morning and welcome.
Thank you. It's my pleasure to be here.
Good. I am tempted to ask you first a number of questions, but I will start with the Honorable Commissioner by asking him, is this a case of all the battles over now that the probe panel has said that there is nothing, no such thing as misconduct or misappropriation found by them? Is it over now, or is it just a case of postponing the doomsday?
Good morning. Before the law, it should be all over, because Section 188, subsection 7(8) said that as soon as the report of the panel is a not guilty charge, no further proceedings are to be undertaken with regards to the impeachment issue. And we believe that is the situation now. But 2 days ago, the PDP held a rally in Lafia under the watchful eye of the Minister of Information with federal legislators, urging the assemblymen to carry on with the impeachment process. What impeachment process is what beats our imagination.
Are you quoting them verbatim,
yes,
or are you paraphrasing and
I am
saying
paraphrasing
that's what?
them.
Okay.
I am paraphrasing them. And
Okay.
already concerned citizens have already begun to express concern over these comments. A rally was held by them to urge the assemblymen to carry on. To carry on what?
But those are not the words of the Minister of Information who was seen in that crowd.
Yes.
He didn't say carry on and impeach the governor, did he?
No, he said he is supporting the assemblymen in the impeachment process. So what support? The impeachment process is completed. A verdict of not guilty has been passed. So what other support?
Maybe he's just identifying with the action of the past.
You need again to read, you need again to listen to him, to listen to the words that he used during that rally and the words of all those who spoke in that rally.
Okay, when you have 20 members of the State Assembly
Of 24.
out of 24 keen on impeaching a governor, don't you think it looks like a doomsday postponed?
The fact is that they have to have allegations of gross misconduct to be certified by a panel, not to be certified by them, to be certified by a panel, to be able to achieve that. As far as we're concerned, the governor, since assumption of office, has not committed any misconduct to warrant any impeachment, of a gross nature to warrant any impeachment. And we believe he has the support of the people of the state. He has the support of his conscience that has made him to continue to administer the state in a most transparent and accountable manner.
Okay. Mr. Shitu, you're a legal practitioner. In the eyes of the law, is this saga over?
Well, my own perspective is bipartisan. I'm in favor of respect for constitutionalism and the rule of law. And that's the perspective that we should be concerned about, because that is what will make our democracy to survive. The impeachment, like all of us know, is both a constitutional process as well as a political process. Political process in the sense that it is supposed to be within the purview of the State House of Assembly, subject to following certain prescribed procedures clearly stated in the Constitution. Those procedures are stated in Section 188.1 down to Section 188.11. And Section 188.10 specifically stipulates that when those processes are followed, then the judiciary will not intervene. But when those processes are not followed, then the judiciary as custodian of the Constitution will intervene on the side of constitutionalism. Now, if you look at those processes, the first procedure is that there must be a notice of allegation signed by not less than 1/3 of the members presented to the Speaker.
1/3 or 2/3?
1/3.
Okay.
Notice of allegation signed by not less than 1/3 presented to the Speaker. Now, upon receipt of that notice of allegation, within 7 days, the Speaker will cause that notice, a copy of that notice to be served on the office holder, and then every member of the House. Now, within 14 days after that notice is served, the Assembly will then resolve by motion whether to investigate or not to investigate the allegations contained in the notice. And then, if they now decide to investigate, it can only take place, they can only resolve to investigate by 2/3 of the members. 2/3 of the members will now resolve whether to investigate. When they now investigate and they pass it, that they want to investigate, they make a request. The Speaker will make a request to the Chief Justice to constitute a panel of 7 members within 7 days of that receipt of that motion directing investigation. Now, the CJ at that stage has a discretion to choose 7 members who are bipartisan, in terms of you should not belong to any legislative house. They should not belong to any political party. They should not belong to any federal civil service, any service, public service.
So the members of the House had, what their objection had merit, because there was a PDP member who was a member of that panel.
Well, if it is asserted that is true, then that will be a violation of the Constitution.
And in that case, what would be done?
You see, there are precedents. If you look at what has happened in the past, say in Anambra State, in Plateau State, and in the Ekiti State, where the Chief Judge is seen to have played a partition role in the process, the NJC had cause to intervene to suspend those Chief Judges. But you see, there's a procedure. At the time the Chief Judge is taking that action, he has a discretion, which is vested in him to choose. If subsequently you have an objection to the members, what you can do is to petition the NJC or challenge the action in court. But as it is now, the CJ has exercised his discretion. Whether that discretion is judicially exercised is a matter for another day. Now that discretion has been exercised, because if you look at the wordings of the Constitution, he said the members who, in the opinion of the CJ, so the CJ has an absolute discretion to determine who will be the members of the panel. Now, after the panel 6, if the panel decides, looks into the allegations and finds out that there's no merit in the allegations, it will report to the House. And by virtue of Section 188, Subsection 8 of the Constitution, that report is conclusive. Once there's a report that the allegation remains unsubstantiated, that is the end of the exercise. You can no longer. But if the panel finds as a matter of fact that there's substance in the allegation, then the members, by 2/3 members, will resolve and then to impeach. You see, so looking at it as it is now, there's a lot of constitutional issues that have been raised here. One, the CJ has exercised the powers vested in him by the Constitution to constitute a panel. Now that power vested in the CJ has not been set aside, either by the NJC or by a court order, because when the CJ is doing this, he's acting administratively. Now, as it is, in the eyes of the law, the process, as far as the Nasarawa State, impeachment is concerned, for now, is concluded.
Okay.
In the eye of the law. But you see, when you say the process is concluded, we are having respect